After weeks of testimony from witnesses in the murder trial of former Minneapolis police officer Derek Chauvin, jurors' deliberations are continuing for a second day. Chauvin is charged with second-degree murder, third-degree murder, and second-degree manslaughter. If the jury convicts him, he faces a maximum of 40 years in prison. Yesterday, the trial took another twist when the defense asked the judge for a mistrial over comments made by California Congresswoman Maxine Waters at a weekend rally in Brooklyn Center, Minnesota. Let's play a bit of what she said.
We got to stay on the street, and we've got to get more active. We've got to get more confrontational. We've got to make sure that they know that we mean business.
All right, let's bring in Jessica Levinson. She is a CBS News legal contributor and a professor at Loyola Law School. So in an interview yesterday, House Speaker Nancy Pelosi said that California Congresswoman Maxine Waters has nothing to apologize for, those comments that she made over the weekend that we just heard. But critics have argued that, her words could incite violence or encourage it. And Derek Chauvin's defense actually asked for a mistrial based on those words. Brooklyn Center is not too far from where the trial is taking place. Now, the judge said that he didn't think that her words were grounds for a mistrial, but could possibly be grounds for appeal later on. I just want to get your take on that. Help us understand, the likelihood of her words having any sort of impact on an appeal or being grounds for an appeal. And quite frankly, after listening to the trial, do you hear any grounds for appeal sort of anywhere? Should there be a conviction?
The answers, although it's always, I should be careful about being this specific, but the answers are no, not really, and no, in the sense that I don't think that these statements will be grounds for a successful appeal. I think if Officer Chauvin is convicted, that the defense will include these statements in an appeal, but will it be enough to say we should overturn this hypothetical verdict? I don't think it will reach that threshold. The same thing with respect to what we've seen throughout the trial. And remember, there was, in the very beginning of the trial, there were the news that the city of Minneapolis had settled to the tune of $27 million with George Floyd's family. And the defense said, we need a mistrial because of that, I believe. He said, that's going to taint the jury. The issue for the defense and for the prosecution is that there is so much news coverage. And that's why the judge says every night to the jury, don't watch the news, don't listen to the news, don't talk to anybody about this case, because he's trying to build this kind of pristine, sanitary environment in the middle of a very, less than sanitary world, in the sense that we don't live in a bubble. And so do I see grounds for an appeal at this point? I see that there will be an appeal because there almost always is. But I think that if you look at the rulings by the judge, if you look at the instructions that he gave, he's been very careful throughout. Do I think that these comments would amount to overturning this verdict? I don't. But and for the same reason that the judge in that moment said, I'm not going to declare a mistrial. We've gone through this entire process. And he said, I don't want members of Congress to say that, but I don't think that enough jurors would listen such that it would impede their ability to do their job once they're in that deliberation room.
Yeah, there's a political equation to this, Jessica, as you know, which is not important, but the importance as to how it relates to this trial is the one that I'm sort of interested at. And as you pointed to the judge essentially listening to the defense lawyer's arguments as to why he would like to see a mistrial declared, the judge made it clear that he wishes, he hopes, that lawmakers, members of Congress, politicians would stop using language that is disrespectful to what he called the rule of law and the separation of powers, the judicial branch from the legislative. But he said also what a congresswoman's opinion is doesn't really matter, and that is why the motion for a mistrial is denied. And I guess he's saying that, right, because Congresswoman Waters has a First Amendment right to say whatever she wants, and she's not the first person to say, hey, we should be protesting police brutality in the streets. I mean, it's not something unheard of. But I do wonder if the judge should have asked the jurors if they had heard those comments.
Well, once the judge starts talking about those comments, arguably you're opening up a little bit of a can of worms or a Pandora's box, saying, I want to go ahead and survey you. Were you aware of the news? At a certain point, the jury is going to have to admit, yes, Your Honor, actually, I went against your directives. Every night you tell us not to watch the news. We know we're not supposed to do that, but in fact, I did hear about these comments. Now, I think your question brings up a number of really important broader points here. One is that the judge said two things that actually, to me, sounded different. And I think in the beginning, what he was saying is she absolutely shouldn't have said this because he's upset. He does not want there to be any question, any grounds for a mistrial. He wants to run a very tight ship. But then he says, well, but it doesn't really affect any jurors, and so it's not grounds for a mistrial. So it can't quite be that those two things are true at the same time. Again, I think in the beginning, he's saying, everybody stop saying these things. We're so close to the finish line. But of course, Vlad, as you bring up, let's remember everybody's role here. I mean, the judge is trying to preside over a trial where there are no questions, where there's nothing for either side to bring up on appeal. And lawmakers are trying to explain to everybody, let's not forget the background of this case. Let's not forget why this is a case we're talking about. Let's not forget about issues of systemic injustice. Let's not forget about having to reform the criminal justice system. In an ideal world, does Maxine Waters pick, different words at a different time so that we don't have to have this question about the jury and whether the jury would be tainted? I would say yes, but one can understand absolutely where those comments come from. Should the judge have polled the jury? I think in this case, the judge had made the determination that even if they heard those comments, it wasn't going to be enough to undercut their ability to do their job. And again, now they are in fact sequestered, so we won't have those questions anymore.
So let's talk about what we actually heard in the courtroom yesterday. They were closing arguments, and the judge delivered his directions and instructions to the jury. He really stressed that Derek Chauvin remains innocent until he's proven guilty beyond a reasonable doubt. I want to play some of the sound from the judge.
The defendant is presumed innocent of the charges made. This presumption remains with the defendant unless and until he has been proven guilty beyond a reasonable doubt. The fact that the defendant has been brought before the court by the ordinary processes of the law and is on trial should not be considered by you in any way suggesting guilt. The burden of proving guilt is on the state. The defendant does not have to prove his innocence. Proof beyond a reasonable doubt is such proof as ordinarily prudent men and women would act upon in their most important affairs.
All right, so both sides gave their closing arguments. The defense was really, really long, but prosecution was pretty long too. And I thought when the prosecution started their rebuttal, and he said, "I'm not going to take too much of your time," I really thought it was going to be 15, 20 minutes, but it didn't. It took quite a while as well. What's your take, your assessment on how both sides did?
I think you're right in the sense that I think both sides maybe weren't reading the room of the jurors, although we know from their comments that the jurors, and from reporting that the jurors looked like, okay, I think I get the point here. And that, I think, was, if we were to criticize the prosecution on any point at all, the idea that they may have at a certain point started to inch into overplaying the case, into over-trying the case. Now, how do I think both sides did? Look, the prosecution, I think, from the beginning framed this as, it's not that complicated. It's quite simple. I'm going to show you the video. We're going to then walk through a lot of what happened behind the video, but you can trust what you saw. This is not something where we have to question what happened when and by who. You can watch it for yourselves, and I'm just going to help guide you in your journey of talking about what happened in that video. The defense, of course, as defenses typically do, tried to complicate it and say, I know you saw this video, but there's a lot that happened before, a lot that happened after, a lot that happened kind of in the background. And so let's talk about other causes of death. Let's talk about pre-existing conditions. Let's talk about drug use. The defense, I think, had a little bit of let's just throw a lot in a wall and see if anything sticks. which makes sense because, as we heard from that jury instruction, the defense has a really different role. The prosecution has to build an entire house from the bottom up. The defense just has to say, you know what, I'm going to take out this one key part and put reasonable doubt in one juror's head. And that is a hung jury. That is a win, in a way, for the defense. So the defense started out very clearly with reasonable doubt. And that has been the theme throughout. They're saying that there can be reasonable doubt and that there are other causes here. You know, on behalf of the jury, do I wish that they could have done that maybe a little bit more efficiently? I think this is always a potential sandpit for attorneys, which is they've been working on these cases for so long, they want to make sure that they don't forget one thing to tell the jury, but then they have to, I have this in class where you have to look at the students and say, okay, I think I made my point here and we're all done. So in sum, I think the prosecution made a really strong case.
Were you surprised at how long Mr. Nelson went? Because, as you say, and this is sometimes hard for people who are not sort of schooled in this stuff, he doesn't have to, his only job is to introduce that reasonable doubt, right? That a juror, that's the only thing that he needs to succeed in doing, to do his job efficiently, is to introduce that reasonable doubt to one juror. Guilt is the prosecutor's job. Innocence has to do with, like, the media, right? I mean, he's never said, Mr. Nelson, that Derek Chauvin wasn't there and he didn't do the things that we saw in the video. But he talked about what a reasonable police officer would do. And so do you think that in going as long as he did, that he was able to do that? Or would it have been more efficient, as you say, Jessica, to keep it shorter and perhaps a little sweeter?
Yeah, here's a really unsatisfying answer, which is we'll know if there's one juror that decides to hang, particularly on the 2 murder counts. So we'll know if they poll the jury at the end and there's a juror who says, you know what, I wasn't quite sure, but the defense really put it together for me for why I still was not able to get past that highest threshold of beyond a reasonable doubt. The defense, again, is hoping something catches fire. They're just trying to light a bunch of matches. If one of them catches fire, then yes, maybe the other jurors feel like, gosh, this is going on so long that he's starting to turn off the other jurors, but he's done his job. It did feel, though, like he could have picked up the clip at certain points. And again, you don't want to have the jurors and then really just have them turn against you because they're saying you're wasting our time, you're wasting our most precious resource. And there were moments in the trial where I thought the defense could have done a better job of trying to explicitly explain to the jury, here's what we're trying to do here. But again, a very different role. It's not just which side of the scales tips. It's having to look at the scales in a very different threshold when it comes to these criminal cases where it's proof beyond a reasonable doubt.
And for the prosecutor, Jessica,
I thought that was a really interesting observation, because as I was listening to the defense's very, very long closing argument, I thought to myself, well, even though this is long, your argument is actually much clearer than it was when I was listening to the witnesses that they put on the stand. And I thought maybe that's part of the reason why the closing arguments are so long, is because for whatever reason, at least for me as an observer, they didn't quite sort of piece it together as well when they were questioning the witnesses. I don't know if you felt the same way, Jessica.
Absolutely. And I think you hit on something that's so interesting, which is some attorneys, particularly some defense attorneys, I think like to go through a case where they're really pulling that case apart piece by piece. And it's not always clear exactly where are we going? And then at the end, they like to have this big kind of reveal moment. Look at, that's why we did all that. They like to have a moment where they can, with the jury, kind of say, and now there's the final brushstroke, and that's why we painstakingly did this line and this line. It looked like they weren't all going to connect, and there they are. They all come together. it's really just a difference in, I think it's such a good question. It's a difference in strategy. I would personally feel nervous that you're not guiding the jury step by step. And maybe this is just how I am in the classroom. I don't want everything to come together at the end of the semester. I want the students to be with me every day. But some attorneys, again, they like that kind of big wow moment. And I think that's what he's hoping for. But when the big wow comes slowly and for a long period of time, again, it is a certain risk calculation there.
Ultimately, though, Jessica, with regards to the prosecution, so the defense attorney introduces this reasonable doubt, but the prosecution is basically saying to the jury, in addition to the number of witnesses that the prosecution that they brought up to testify, and I'm paraphrasing the legendary Chico Marx of Marx Brothers fame, who are you going to believe? Are you going to believe me, or are you going to believe your lying eyes? And how much of that carries weight with jurors generally? I mean, here we have the video evidence, in addition to all those other witness testimonies.
Yeah, Vlad, I think this is something we talked about last week a little bit, which is this case is so different because of the video. And there did not have to be a, he said, she said. And I think it was so powerful for the jury that they were able to have that evidence. And that's why it was the first thing that the prosecution showed. And I think the prosecution with it was 38 witnesses that they called, the defense called 7 witnesses. The prosecution with those 38 witnesses wasn't trying to create a picture. They were just trying to support that picture. And the prosecution, in terms of, you asked about reasonable doubt, they're going to emphasize it has to be reasonable. It's not any kernel of doubt. It's not any moment where you think, is there a possibility of something else? Now, this is something we struggle with in terms of criminal law, which is defining what a reasonable person did, what reasonable doubt really is. I mean, I joke with my students about this. Show me the reasonably prudent person. Show me the, objective member of the community. But the prosecution, I think, again, it's this, you can believe your eyes. Look at the video. All we did for you is bring forward 38 people who helped support what you already knew. I think that's what the prosecution has really tried to say throughout. We're not creating this for you. You saw this. The defense is going to try and tell you don't trust yourself. There's no reason not to. Here are these 38 people who will explain why you can trust yourself. Yeah, because at the end of the day, I sort of, as I was listening to both arguments put forth, I thought to myself, I mean, in another situation, if you go out, for example, and you go to a bar and you have a couple beers and you enjoy your time at the bar, but the moment you step outside of the bar, you get into a fight, and then you say to the police officer, well, for 3 hours, I was great. I was wonderful. I didn't do anything wrong. So you shouldn't really hold me accountable for the actions here. Isn't that what the defense attorney is asking the jurors to sort of take into account as they think about the reasonable doubt argument? Yeah, that's a really interesting question. I mean, I think the defense attorneys, and I don't mean this in a pejorative sense, but any way they can get one juror to get past that threshold of reasonable doubt is a way they want that juror to think about reasonable doubt. And yes, I think that the defense, it's very interesting in the sense that on the one hand, they want to give the jurors a much bigger picture of everything that happened. They want to bring in evidence of although it wasn't used for character, of prior drug use, of previous situations where George Floyd was pulled over by the police. They want to talk about, what led up to the video. On the other hand, as you point out, they don't want to talk about, the 3 hours when you were behaving well in the bar. And they're trying to focus on these little slices and talking about, well, what really did cause George Floyd's death in that moment? So it's an interesting strategy where they're, at the one hand, trying to make it, I think, much longer and more comprehensive. And then at the other hand, almost picking out pieces of film and trying to create little bits of reasonable doubt in these little snapshot moments. It will be, I'm just fascinated to see how long the jury will take in their deliberations. And in part because of the strategy, Vlad, that you talked about. And if it takes a long time, I think the better that is for the defense. If we get a verdict quickly, if the jurors walk into that room and say, for the first moment, we're allowed now to talk about the one thing we have in common, the one thing we couldn't talk about for the last 3.5 weeks, and say, let's take a quick vote, and they come back with a guilty vote, that's really good for the prosecution. If it's Thursday, if it's Friday, that's looking better for the defense.
All right, Jessica Levinson, we'll be waiting. Thank you very much.
Thank you.